Okay, good morning everyone, and apologies for the delayed start. We had a bit of a technical gremlin in the system there. Hopefully all is now good. Welcome to another Wednesday morning online seminar. Today we're talking about how to get through disputes and keep your cash, and that is being presented by Henry Hathaway. Without further ado, to prevent any further delay, I will hand over to Henry. So Henry, please take it away. Don't forget, by the way, sorry, you can ask questions by the Q&A chat facility or Q&A facility, and Henry will answer these at the end. Thank you.
Good morning. Thanks very much. Henry Hathaway is my name, and I'm consultant solicitor with Silver Shemmings Ash. And the main topic this morning is discussing how to get through ADR, or alternative dispute resolution, and keep your cash. So essentially, when we view disputes within the wider construction arena, one of the key points that really becomes very obvious at the very end, disputes can be a very unsatisfactory, it can be a very unpleasant experience for many different companies. And ultimately the goal will be at some point to suggest, how do we avoid disputes? Or how do we get through? Or what are the necessary points to understand what does the balance of probabilities mean? And how do we apply that to when we are actually undertaking a particular project, the ordinary course of the business from day to day, and with the complete objective to avoid disputes being formalized between parties, and to indeed actually make the best benefits. Okay, so when we actually look towards what the usual kind of dispute resolution at this moment, and that's generally within the industry, we'd say adjudication, arbitration, mediation, or conciliation. And of course, we have litigation as well, Part 7 or Part 8 proceedings. But ultimately, if we look towards these points, which we will describe them, these are dispute resolution points. The key of this for many parties will be dispute avoidance completely and entirely, and to understand what is it that will actually be taken as the right steps. When does it start? How do we actually avoid disputes and avoid these different points? But if we look, say, at arbitration first. Arbitration is in private as opposed to being in public. An impartial professional is instructed to make a decision on the dispute, which in turn means that it can be quicker for cases to be resolved. However, the arbitrator's time is paid for by the parties, unlike a judge. There's also limited grounds to appeal the arbitrator's decision. The arbitrator has the power to award costs. The parties have to agree, therefore, often found in international overseas contracts, as allows the parties to agree a neutral venue and mechanism for dispute resolution at the outset. So traditionally, a lot of parties would actually recognize that, especially after dealing with JCTs, that usually over the last number of years, arbitration has been struck out quite a number of times. And what is the main reason? The main reason really was expense. It was the perceived expense of arbitration that inherently, since it came into in 1996, the 1996 Act is the latest in the point of arbitration. So once the Act became a part, it had quite a lot of success. The difficulty was it became so expensive. And ultimately, it does have its benefits. It is legally binding. So if we look towards, say, adjudication, it's binding on the parties until it's otherwise resolved by a court or tribunal. Arbitration is a legal decision on that point. And of course, you can have those separate parties. It is one of those aspects that has lost favor quite a lot. It obviously is going to be one area which would be dealt with very well internationally, on the basis that it allows for the seat and the jurisdiction to be cited and be named. And ultimately then we are looking to say internationally wise, because obviously adjudication is not processed as under the statute of the UK. So arbitration is that it's fallen from grace. We actually see it as being one of with a very high potential of being reintroduced, especially for the more complex, where adjudication has been criticized for dealing with overly complex, not just purely payment. One of the different points why we think that arbitration could become more popular is because, in fact, adjudication in a lot of respects has become just as expensive in a lot of areas. In fact, there is all of the pilot schemes, attempts pilot schemes to make adjudication a bit cheaper, but isn't there an avenue that arbitration could actually make quite a return, deal with a number of different disputes, have experts, and have those expert opinions as well. So if we look at mediation then, mediation is becoming the most common method of alternative dispute resolution and involves appointing a neutral, independent, trained mediator. It's entirely voluntary and conducted on without prejudice basis. Often the mediator will gather the parties together at the start of the day so as to allow each party to set out its position. The parties then split into separate rooms, with the mediator going between the rooms throughout the course of the day to try and narrow the issues in dispute, with the ultimate view of achieving a settlement. The intervention of an independent mediator can sometimes help parties to take a step back from litigation and consider matters from a more objective perspective. This can be help in facilitating settlement in even the most contested disputes. They tend to engage in mediation after formal statements of case and the court proceedings have been served, which means that the expense of preparing a case for trial, such as disclosure, witness evidence, and the trial itself, can be avoided if the case settles at mediation. The court encourages parties to engage in mediation, and failure to engage in settlement discussions without justifiable reason can lead to cost consequences, even if the offending party is ultimately successful at trial. Generally, always the commentary point is that litigation contention ought to be seen as a last resort, not as the first resort. Mediation, of course, parties will be expected, and it would want to be quite a good reason to explain to a court why a party did not partake in mediation or settlement discussions, or an attempt at least to do so. The timing usually follows the same type of patterns. If there are expert witnesses, and the exchange of expert reports is usually a crucial time, as well as the witness evidence as well. The difficulty, of course, is that at the stage of the directions in complete and pure litigation, part 7, that can be quite a way down the actual directions timetable. So the incurred cost at that stage can be quite expensive at that point, especially when we consider where before formal dispute occurs that we have the pre-action protocol. The pre-action protocol is a stage basis before you ever contemplate entering into litigation, where the parties seek to understand each other's case more broadly, of course, and then to have a meeting in order to attempt to settle differences and avoid litigation at all. These are ultimately that meeting within pre-action protocol. We'd like to attempt to turn that into a mediation if the parties agree. There must be agreement. The benefits here now are getting a little bit more that the parties remain in control. They remain very much in control with the mediator. The mediator is not there to actually interject per se, or to actually force, or to in any shape or form comment on the merits particularly. And they're there purely to facilitate the environment for parties to try and seek to make an agreement. But ultimately, the powerful point behind mediation is that the parties do remain in complete control of decision making. That is one of the downsides, of course, of going to adjudication or an arbitration or indeed court, that essentially the arguments, to some respects, are taken out of your hands. First of all, you will rely upon representatives, which is absolutely fine. But that's when the actual decision either comes from an adjudicator, an arbitrator, or a judge, it is their decision and or the judgment in terms of court. But the ability for parties to recognize their ultimate worth by engaging in negotiations is perhaps one of the most consistently best performing basis to resolve any disputes, and the ability to actually manage to formulate the evidence to actually provide that. When we look towards conciliation, conciliation is an alternative out-of-court dispute resolution instrument. Like mediation, conciliation is voluntary, flexible, confidential, and interest-based process. Parties seek to reach an amicable dispute settlement with the assistance of the conciliator, who acts as a neutral third party. Conciliator, not the parties, often develops the proposals and the terms of settlement. And towards adjudication, what we note is adjudication is widely recognized as being a pay-now, argue later mechanism, resolving disputes, and is most common used for resolving construction disputes, as the parties to a construction contract cannot contract out of it. It is a statutory right. Section 108 of the Construction Act and subsections means that a dispute can be referred at any time. Whilst it can be extended, the adjudication period is generally 28-day procedure, which is started by a party serving a notice. There are strict time limits to comply with, and when dealing with the adjudication, generally an adjudicator has no power to award costs unless the parties have otherwise agreed, but in most terms, costs follow the event. Costs follow the event, and ultimately then usually the loser will pay the costs of the adjudicator's fees itself. What is generally not recoverable are the costs of the individual parties themselves. So that can be one of the downsides. It's very easy to get into, but you do not recover your own costs, even if you are successful. Adjudication awards are enforced by the courts, which is designed to protect cash flow of businesses by preventing one party from withholding payments for significant periods of time. Adjudication, however, does not finally dispose of the matter. The adjudicator's decision often lasts until practical completion, at which point it can be arbitrated or litigated if not accepted. Generally, adjudication is appropriate for dealing with claims relating to interest payment and extensions of time for completion of works, delay, and destruction of works in the final count. So it's extended on towards many different arguments have been raised in relation to should it go with professional negligence, what areas. Some of the disputes are getting very, very technically large. They're getting to a point where the issues are technical in nature. Certainly having in the last number of adjudications dealing with quite complex mechanical and electrical systems, where a deep understanding would be generally required of what the workings of the mechanical and electrical system would be. And the question then has to be raised as to whether or not adjudication, formerly one that had consistently been about payment, and one would say that you have to get to the heart of the issue beforehand, but to resolve such very technical points is adjudication the right area. We're talking about also the costs. The costs have escalated, of course, to such a large degree in an adjudication, which is to avoid, really, a lot of parties are seeking to, in some instances, seek different alternatives. Certainly the costs of running a particular adjudication and the risk, of course, of getting a wrong decision. It's not a final decision unless the parties are bound to it, but it can be decided, of course, and the whole merits opened up through proceedings in a court. The decision of the adjudicator is binding until the dispute is finally determined by litigation or arbitration or by the agreement. Only disputes under the contract may be referred. Some disputes will not be capable of adjudication, such as disputes regarding whether a contract exists or not, claims in tort for misrepresentation, rectification of the contract due to mistake. These are not claims under the contract. Adjudication under the contract, the parties must have a dispute or difference which arises under the contract. Dispute must have crystallized. Scheme Part 1 is statutory instrument. It sets out the rules that covers each stage of the adjudication from the initial notice to enforcement. What are the initial steps to be followed? So in general terms, how parties actually interact and forward. So one of the chief jurisdiction challenges will be always, has a dispute crystallized in the first event? If there is no dispute, but what constitutes a dispute? What constitutes a difference? The courts had to wrestle with this for quite a while, and we went through the low threshold or a Halki criteria, and then eventually the issue was resolved in the Court of Appeal with AMEC, the case in AMEC, and ultimately there was a number of different points that actually constituted what the dispute difference would be, but ultimately it's an objective test. Simply by ignoring a party or not responding would be enough to follow. Certainly if you make such demands over the period of time, over 7 or 14 days, or make such requests, those either are not fulfilled or unheard, then of course clearly there's a difference. If there's non-payment, it simply will be that there's a difference between the parties as well. But this is the critical step, because by the time a party refers, they must be ready with their evidence. Ultimately, you are to set out your whole basis of claim and your allegations against the parties whom you're referring against, the respondent, in order to set out concisely and very clearly what you are actually claiming. And that's the clear points. What the redress is, and in a lot of cases, it is often not as clear as it ought to be to an adjudicator. What is it that the party is actually looking for? And what is it? To clearly identify what was it that the parties intended at the time of contract, what did the contract say, how did it arise, what did the parties do, as in what was the breach, which specific terms were breached from this, and then of course what was the losses and the substantiation, and are we now in a comfortable or good enough position to discharge our burden in respect of the burden, to discharge the burden of demonstrating that such losses are not too remote. We did exercise mitigation, and lastly as well, there's no break in the chain of causation, and the causation simply is not interrupted. Those simple rules sometimes fail. So one of the difficulties that parties do quite often is that they enter into quite long descriptions of narratives, of how parties over elaborate and certainly over emotive points to order to gain weight, I expect, towards different arguments. The ability to be clear and concise, not repetitive on certain instances or allegations, will most likely assist the party. Demonstration of what the breach is, what was it that the parties intended, and what did they agree to, and what was that crystallized breach, what was the breach. Really clear evidence supporting that will certainly be much more clear in that respect. The timeline we look towards is the notice. The notice can be issued or served at any time. We have the referral, which now counts as day 0. Usually a party the opposition will serve a response. In the response, you would expect that they will defend on each point and each allegation made against it. Now, they are free to raise any points of defense that they so wish, and that is held law, and they do not necessarily need to remain in confines. Sometimes there is a meeting, and of course, like, just the instance, the meeting can happen any time, so necessarily it doesn't have to follow strictly in this course. But ultimately, that will be an issue of cost, or whether the adjudicator will see it as particular benefit. Sometimes the parties may request it, but depending on how or what the benefit would be. Ultimately, meetings within adjudications can be quite beneficial. And of course, there is that element of parties being free to mediate at any time as well. The referring party will be expected to issue a reply to the response. And this is where the issue should be becoming more narrow at this stage. One would not expect that new arguments should be raised, but realistically that the issues are being narrowed and that they are in direct response to what the response has actually called for, especially if there is a counter position as well. Of course, we'd have areas with rejoinder or surrejoinder, documents in support, of course, witness statements to assist. The rules don't follow, of course, the CPR, civil procedure rules, but it's very, very important that parties do recognize that there are rules in relation to witness statements, especially with the statement of truth. And one must really have the explanation of what the consequences are for not having honest belief, and certainly what it is. And by signing the statement of truth, do remember as well that these documents are documents that may well be coming under subject later on in court as well. So it's very, very important that how pleadings are put forward. We've had certain instances of Chichester, Grosvenor, certain aspects of where elements of fraud were alleged, and there seems to be that tension as well as to how parties will make such allegations during the course of an adjudication, and how the enforceability of that actually arises afterwards as well. Enforcement usually means the enforcement by way of summary judgment. The courts show from day one that they would uphold an adjudicator's decision and order enforcement. And there's many different points of case law in this, and they've been very, very clear, even recently, the most recent cases, that they will give effect to the adjudicator's decision, and especially on the basis that if it's there is no challenge to jurisdiction and there's no breach of natural justice. In fact, even on the face of it, if the adjudicator has answered the right question but has got it materially wrong, the decision is still enforceable. The reason why this is because adjudication is seen as not as the final redress for a party. They're not prejudiced of their overall rights because they can have the full dispute litigated upon. The difficulty, of course, with that theory, although very, very practical and very understandable, that they want to give good effect and make sure that there is teeth to the overall adjudication process. One might imagine that if there was a different approach taken by the courts, that the enforcement procedure would nearly become a type of appeal process, which is not what it seeks to do. It seeks to enforce it. Ultimately, the floodgates would open. You would have a number of different instances of where parties who are not happy with the result of an adjudication or decision on adjudication now using the enforcement procedure as some form of appeal. That's not the purpose at all. If a party is inherently dissatisfied or simply believes that the result is not agreeable to, it ought to commence Part 7 proceedings or another form of dispute resolution through the courts. And that is incredibly important. So it is one that in the absence of any jurisdictional challenge or and understanding that there is no breach of natural justice, ultimately it is more likely than not that the courts will enforce. If the adjudicator has answered the correct question and the wrong, then the decision will be enforceable. If the adjudicator has decided the wrong question, the decision will not be enforceable. That becomes a matter of the jurisdiction. The adjudicator must answer the question that's referred and ultimately must discharge that point. So we find that some of the quite very good adjudicators, they will spend time explaining in their reasoned decisions what in particular the question put to them was, and in effect how they have answered that question referred to them. What arguments can the defendant put forward to defend the application for summary judgment? So some of the common things that we see would be, for example, that there is no contract. So this is one that we actually see more regular than we would actually think ordinarily, and the most common position is that if two parties have some form of agreement, and do remember as well that oral contracts can be adjudicated upon, it's just more difficult because discharging your burden of proof as to the contents of an oral conversation is much more difficult than it would be in writing. But ultimately, the courts have always been in traditional litigation. They're not going to be very much impressed by suggesting that two parties have come together, have undertaken activities for value. And certainly if a party can see the constituent elements of a contract, be they as straightforward as offer, acceptance, consideration, and intention to create legal relations, simply put, there will be a contract during that course of, or at a time. But certainly if there is no contract, there is not going to be an adjudication. The adjudicator didn't have jurisdiction, so there's a number of different points. Has the matter been decided before? Is it substantially the same issue in dispute? And if it has been decided, then the adjudicator will not have jurisdiction. And there are a number of different reasons, and you will expect that parties, as a respondent, first point that they must do is they must reserve, at the very least, their position generally, if not specifically, if they have a key point of a specific jurisdiction challenge. But generally, they must reserve the position. If they do not, they may well prejudice their position if it later is found that there is a jurisdictional challenge, and they try and challenge that at the time of enforcement. So as early as possible, whether be it in the first communication with the adjudicator, or certainly at the very latest, one might be with response. But generally, it should be one of the first correspondence points with the adjudicator to make it known that the position is going to be reserved. If, for example, the adjudicator acted contrary to the rules of natural justice, so we've seen often that arguments, rules of natural justice, and how that extends to, again, this is one of the two limbs of what would challenge a decision being enforced. But rules of natural justice doesn't simply mean or extend to a party being unhappy, of course, with how a decision has actually transpired. A good example would be if a respondent submitted a defense, but none of the contents of the defense were taken into account. That would be an example. But any glancing ability of the adjudicator to bring that into the forefront will usually satisfy, but it would be take a disregard or the material circumstances. But again, it's going to be an objective basis on how it affected and what were the rules. The dispute is the same as one which has been referred to in adjudication previously. Parties are bound to the decision and not to be referred again until formal litigation. Now, of course, that became quite a little bit of points of contention because of payment disputes where we had smash and grabs. And of course, Pace versus Harding was one case where matters. So essentially, interim certificates versus the final certificate or final account valuation. And of course, then the ability to say whether there's smash and grab in any instance. So that was a good example. But the more typical ones is if an adjudicator has decided on a matter, ultimately, absent any of those rules that they stand, the parties are bound to those, unless it is actually, unless of course it's open to the parties. So this is where the parties usually get quite clever, and they try and would find a narrow element, one which wasn't decided. The adjudicator answered the wrong question. And this again, of course, is one good reason why an adjudicator will spend quite a lot of time ensuring that they have, in fact, answered the right question as referred. So, example of defects: the unfitness adjudicator, bias, dealing with a matter which is not part of adjudication, exceeding the authority, the jurisdiction which has been set out, failing to deal with a matter that was in the notice or referred, decision is unclear, for example, failing to state an identifiable sum, illegality, breach of natural justice. It's important to distinguish between claims under the express terms of contract and common law claims. And of course, what contract you're dealing with, because it's quite common for parties under a contract to actually express to exclude common law claims. That is more than available, certainly in NEC, all rights under the contract. And of course, but JCT in its unamended format does preserve common law rights. So what does that mean? A party may, the benefit to a party will be for claims under the contract is that it's an express authority or power for a CEA or an EA to award sums on an interim basis, which helps cash flow, etc. And that's absolutely fine, and they're under the rules. So Section 4 has very detailed provisions for payments and how those sums arise. And of course, loss and expense can be dealt with on an interim basis. But the contractor and the employer, they may choose to wait to the very end of the contract and sue under common law. And ultimately, what will usually happen, especially if there's a time bar, is that parties will actually, at that stage, seek to exclude common law rights. And that's when they will attempt then to ensure that all of the rights or redresses under the contract. This would be importantly so because if a party has not obliged itself against, say, for example, time bar clauses or condition precedents, in the absence of barring common law claims, a party may simply avoid all of those and just go straight for common law if the matter has not been excluded. So just to talk briefly now towards this point is administration and communication. One of the clear points when we look at cases, and it's very easy to follow trends and patterns throughout disputes and how they are decided, when a party wins, when they lose or they don't get exactly what they want, and to really find out with a lot of data, a lot of analysis of all of the cases that actually arise, and to really home in what was it that went right and what was it that went wrong in terms of the quality of evidence. Construction is one of those industries which has a huge amount of data, correspondence, contemporaneous records. There is an incredible amount available. However, the one difficulty is the arrangement or the alignment, I would actually suggest is a word, between correspondence or between courses of events. I've talked often and separately about, for example, the misalignment between QS activities and planning and recording of time and delay against, for example, quantity surveying activities. And of course, then the site management or any contemporaneous records of how all of these points all bring together. So there's a misalignment, and there's quite often the case that quality of evidence, as it actually is provided and as actually arranged, becomes something that can hinder a party because of its lack of organization. So one of the major points is the construction industry does hold a lot of information, a lot of evidence. It's the quality and the arrangement of that really can be the issue, and it can matter the success or failure of any disagreement. When I'm talking about disagreement at any stage, the disagreement and the habits of parties and the ability to resolve variation issues at the time during the interim period, not to leave it to final account. There are rules in relation to valuations, evaluation of variations. They're very clearly set out in Section 5, and time as well. All too often, there is too much of a habit of leaving them to the very end or not setting out a case very early on. But with controlled and deliberate attempts to actually identify the clear evidence that's required from an early stage, will always improve without prejudice in the negotiations surrounding final accounts, with the hope of avoiding formal dispute resolution. But certain different points that really come to play, and the contract and common law position in writing, email likely to be an acceptable form of communication. And then once we look towards send, the issuing of notices, for example. So do we understand what the contract actually calls for? So for example, JCT, it sets out that all communications are to be in writing. So that's the first point, and it's very, very clear on that. But if we are going to serve a notice in a particular format, if we're going to serve 8.4.1, for example, or into termination clauses as specified defaults, we now need to really consider where we are with recorded delivery. So we need to keep an eye on clause 1.7.4, which will detail out when it needs different arrangements or recorded or delivery. So we need to keep an eye on those points. Of course, when we're sending formal letters, or if it's an interim valuation basis, and the identification of those parties, which are set out in the particulars, but we seem to forget those as we move towards. So the email defaults are common, the authority. We've often seen the cases whereby, and it was in the courts quite perhaps about a year and a half ago, where a party taking, and this is something could be quite common right now with the amount of people that are on furlough, is who has the ostensible and actual authority to make a decision under the contract, or indeed who is in the position that they can actually accept service on behalf of the company. And do you directly attract the name of the party, or do you know who that party is? And in the absence of that, who do you actually address it to? In general, all documents ought to be in PDF where necessary. It prevents track change, it prevents editing, but ultimately how documents are actually presented as well, of course. And faxes still do exist. So we mentioned earlier on about the verbal, and verbal contracts do come under adjudication rules, and an oral contract, of course, you can adjudicate upon. But of course, the first line, oh no, I didn't, oh yes, you did. The difficulty, of course, is that in order, once you make an allegation, the burden of proof is upon you. You allege, you must prove. So if you allege that there is a contract in the express terms, and the actual unique terms of that agreement was whatever the details are, it will be for you to actually demonstrate that on the balance of probabilities, the parties did agree to those. A number of different reasonings. Now, if they've been held verbally, one can only imagine then that in the course of a dispute where there may be a denial or certainly a misunderstanding or difference of opinion as to the terms, that does make the first threshold a bit more difficult. So treat evidence as a spectrum. a spectrum on one end being excellent, of very clear expressed words, and on the other, which would be loose verbal conversations. And of course, you want to have the slide over towards the better information. And of course, the post rule, the clause 1.7, we've mentioned as well. So telephone, we often get asked, recorded conversations are admissible entrapment, other parties' awareness entrapment, transcribed by commissioner votes. So the difficulty, of course, would be admissibility. Usually, like knowing the prevalence of where records are actually the different forms. The admissibility, especially if it's without permission, best off to seek permission, of course, then one might be guarded from that. The other aspect as well, of course, is that what we've seen a prevalence of is actually WhatsApp group messages that prove delay, for example, where parties are organizing their day-to-day activities, and the contemporary evidence that surrounds WhatsApp groups has become more and more in terms of what the printouts of those contents of those conversations actually reveal. So when we discuss as well without prejudice communications, this is probably one of the most powerful and a deep, good understanding should often be required of this, especially coming to final account or any negotiations. But the general rule about it is that if you feel that you have a very worthwhile position, in other words, your overall claim is for X amount, but you're willing to settle for a lesser amount in order to bring the matter to a close, you will want to enter with a cloak of protection that ultimately to test, to understand and see is settlement actually available. But ultimately, if it doesn't, you will want to revert to your original position, which you would run in any event. The cloak or the protection surrounding that privilege of your negotiation positions, and the key aspect, I suppose, when a party must consider whether or not without prejudice is appropriate, is if they're willing to make a concession to their overall position. If they're making concessions, and one might imagine this would be very common around final accounts, those ought to be during or under a without prejudice banner. Well, we've seen many different applications. We have seen the contents become important without prejudice just by marking without a document without prejudice may not ultimately provide it with that protection. Similarly, well, I suppose conversely, just because there is a genuine attempt and the contents ought to be without prejudice, and just because it's not marked. But the key concept would be to mark it and to make it very explicit that it is without prejudice to overall rights. That would be, should the negotiations not succeed. You often see that without prejudice, save as cost, lawyers will always suggest that the documents or without prejudice would be revealed after a decision by a judge, and it's to assist in respect of, well, had a party acted reasonably. So if there was a side position whereby a party had tried to negotiate, had tried to resolve it, not allowed to go to dispute, and therefore the cost should be apportioned in respect of the without prejudice conversations that they've had. So that's the save as the cost element as well. Privilege certain communications between parties and legal advisors will always remain private and not disclosable. So we've got litigation and legal privilege in respect of that and how they attract that. So that provides that cloak that the parties may openly discuss, perhaps even liabilities, of the case or how they're going to approach all of those different things. And they are protected from the other side. Ultimately, if these matters do go to the process of disclosure, inherently all documents are disclosable, even if it's adverse to a party's own case. If there are elements where a further party, the applications can be made for what's called specific disclosure. But inherently, we would find that parties, it's very easy in this day and age to write emails, and certainly they don't always, and having reviewed many emails and contents correspondence, parties generally don't put the necessary care and attention into the content of that. We've often seen in disputes, without careful wording or drafting, it can lead to misinterpretation, and it can lead to certainly arguments surrounding whether or not a party actually did in fact mean, or did it conflict, or did it diverge against something else of what they said previously. Those contents, so the wording and how the emails are drafted becomes quite very, very important, as it may well go against the party in the future. And of course, all correspondence are disclosable. Certificates and rolled certifier, there may be a condition precedent to something, i.e. payment completion. Failure to issue, though, cannot prevent precluded entitlement. No person can take advantage of non-fulfillment of a condition, the performance of which he himself is hindered. Essentially, what they're suggesting here is that you can't benefit from your own breach. So ultimately, that just makes quite common sense in law anyway, that if you commit a breach, you should not benefit from that breach. When not to communicate sometimes is just as important. He who asserts must prove, and that's one of the first rules. You must discharge the burden of proof. You must get over the balance of probabilities. On the balance of probabilities, more likely than not, that your version is the more persuasive and correct set of events. But this is the first key point. And earlier on, when I discussed about the simplicity of simple application, of determining what was the term that was breached, what are the losses arising from that, was it too remote, and has the chain of causation been broken? Those different elements, splitting it into liability and splitting into quantum, will always be the set nature of how to approach these. But simply in a clear case, what was the term, what was the breach, what was the circumstances of that breach? So what is the term that was breached? What are the losses that arose from that, in order to put you into the same position you would have been had the term not been breached? Once we see that the incrimination, the burden of proof, so we see that there's clearly two, criminal being, of course, well, the consequences of criminal being beyond all reasonable doubt, and balance probabilities, which would be must be over 51% to provide. So again, the evidence and records that we see, that how the note taken, the purposes of record keeping, evidence, the burden, standard of proof, the forms of records, and the minutes of meeting. We're simply putting that the photographs, the videos, contemporary records, letters and correspondence, type of records, the systems, the archives, all of these, when placed together, and we find that generally a lot of companies have incredibly good information, but the alignment simply is not there. So evidence of delays, for example, and how they actually form true. The ability to impact, we've talked quite a lot about window analysis, and we talked quite a lot about time impact analysis, and how these are formulated and how these actually bring true. What these are really is a form, we generally will find that over the course, that when we break down all of the possible issues that can arise in a dispute, there are generally, they can be narrowed quite simply. So first of all, is it time or money, or is it, what are the natural, point? Is it an extension of time argument? Is it loss and expense? And ultimately, what is it? Is it a disruption claim? Is it, has there been delay on terms of design, procurement? So we can narrow these points down and build out quite a decent chronology, usually of this. But it's the alignment. And retrospectively trying to put these documents together in bundles can be quite laborious, quite costly, and ultimately you may not have the resource to do so. So a lot of these behaviors and habits of formulating these throughout generally do assist. It's knowing how to do them in that instance. Now, friend and foe, key is relevance. All documents relevant to the points in issue and not privileged, and most likely will not be, will have to be disclosed to the other side in form of proceedings. And typical documents, as we mentioned, that even if it's adverse to the party's case itself, it must be disclosable. Litigation in the courts, it's not considered to be an ambush, and the civil procedure rules generally do support that overriding objective as well in that instance. So directors' meeting minutes, for example, internal cost records, profitability forecasts, internal memorandum, computer records, consultant's advice to the employer, or indeed a claim consultant's position as well. Like, no, it doesn't necessarily attract that provision. That was in Walter Lilly versus Mackay in 2012. So what is disclosable and what's not becomes pretty much, if it goes to the heart of the issue, those points will be in order to prove or defeat. And if we then move down through the instance, we go to Abrahamson, and three elements: the importance of records, They are essentially the three elements to a claim, and a successful claim. And he was always maintained that those three elements would be the significant elements of a claim. But of course, the main reason is that without them, it simply is just such an uphill battle, an uphill struggle to discharge the burden. So when we see the forms of notice as required in the T&Cs, notices of start, delays, payment and claim, forms of records, the contract documents, minutes of meetings, photographs, contemporaneous records, letters and correspondence considered, emails, the diaries, programs, progress reports, all of these elements, once kept and once actually considered in an aligned fashion and how they interrelate with each other, becomes quite a powerful element. And they support a chronology of events. And the more powerful and the more considered chronology of events are, then the more likely it is that a party will have that type of evidence and be persuasive. The main instance, of course, is that if it is that considered and that powerful, there is every opportunity to have such representations on a table, at a final account, or even in interim account elements or stages, without having to resort to disputes. And we have to look towards as well how we actually go back to the start, the battle of the forms. We've often talked about that beforehand, the formation of the agreement, signed for record purposes only. So essentially, if we have for record purposes only, which we often quite see on day worksheets or vouchers on that point. But it's going to be very, very difficult if one party has set out that a certain amount of hours has been actually evidenced, they've signed for it, and it's pretty much agreed that is exactly what it is for. It's exactly what it is. It's exactly for record purposes. Usually parties will say, well, I don't want to get into the financial aspects, but I'm going to agree that that's the time that was spent. And that's absolutely fine on that, because normally you would expect that the normal rules of valuation would then take in, but at least there is that those records. Signed by the issuer, unsigned by the recipient. It's better than no record, especially if unchallenged. Signed by the issuer, challenged and amended by the recipient. The challenge is likely to bite unless it's countered. Signed by the issuer, unsigned by the recipient, challenged much later, the challenge is likely to bite. So ultimately is what we do with correspondence. If there's an allegation put against you at a particular time, One would expect later on to say, if something had been said to you or an allegation made out against you or your company, why did you not respond? Why did you not set out the correct course of events, or at least contend? More often than not in the construction industry, and given the superiority or the play in terms of hierarchy within employers, funds, or contractors, subcontractors, we generally find that this imbalance of a superiority position often kicks in, where you get subcontractors who generally don't have that strength or superiority position to answer. And that's simply one of the different key things that really will ultimately be an issue later on, perhaps, but it's completely understandable. But it's an issue that later on, the question will always be asked, why was it that you did not set out your own position at the time when you had an opportunity? If you didn't, is it not the case then that you actually agreed with what they were saying? So for different situations and letters and contents and drafting, it's styled to who you are actually writing to. It's a consistency and concise and factual nature, that if it can be dealt with within a paragraph or 2 paragraphs, why is there a need for 3 or 4 different pages that are repetitive and actually they take away from the clarity of the purpose. Emotion is something that often drifts in. We certainly wouldn't suggest that. A clinical clear point, if you're alleging a breach, set out what the clause was and how it was breached, and therefore what the points in further to that are. And it's a description of the facts leading to that, of course, causation. And explain how the facts lead to a conclusion, set out what the purpose is and what, of course, are the further sets of stages, what is likely to occur, what we expect. Do we expect a reply? Do we expect information? What in case do we actually expect from that? If we're going to mention contractual clauses, in certain terms, again, it's quite by convention and habits. Ordinarily, if it's a specific clause that has been materially breached, we want to make reference to it. But if we are unsure of how clauses work, or what the clause is, or indeed what the purpose of the clause is, or what generally it stands as an underlying meaning, but simply put as well, we have to recognize that clause numbers, especially within the JCT, do vary and do change quite regularly as well, discreetly amongst the different sections. So if we do start inserting wrong clause numbering, at the very least, it can cause confusion. At the very worst, your notice may not be correct. So the diaries as well. Diaries, I would suggest, are probably one of the best contemporaneous records if they're kept correctly. And the work undertaken, the duration, and especially if we can align diaries to what are the baselines. So, for example, if we have a baseline in terms of time, contract, or the program itself, it's very useful to actually set against what was the intention of the parties, and of course, in terms of what was the original bill of quantities. Always reply in appropriate detail as soon as possible to allegations of default or claims. Ensure that meeting minutes are accurately recorded and detailed as reasonably possible. And of course as well, comment indeed on the other side's version of minutes of meetings. The minutes of meetings regularly do come up in respect of evidence. And of course, we would find that some parties do complain that minutes of meetings can be somewhat biased, as what they might suggest, or more favorable to one party's set of events. But of course, if that is the case, it must be contended with, and the record must be set straight at that stage. Communicate lack of mitigation. Mitigation is appropriate. Confirm drawing issues and maintain the drawing register, which is always important. Monitor and record labour and work on site as much as reasonable possible. We do really regard, of course, that verbal instructions be reported in writing. It's critical, contractually and tactically. It's necessary in order to maintain a contractor's entitlement to the payment. Confirmation should be written and submitted as soon as the instruction is given and before compliance. So one of the different points as well is, of course, because this is an industry where we would have loader records and such examples of that as well, which can be tied in, of course, for use. But ultimately, what we would plant and labor records, plant material records, ultimately they are useful internally, but they're also useful for valuations, and are also very useful for evidence in themselves. And such are the examples we put forward. So what will have to be proved in a claim, and how best can records help? All claims essentially in the benchmark for all construction lawyers will come down to a claim, and recoverability or damages will come down to the case in 1854 of Hadley versus Baxendale. It simply splits into two elements. When parties read through the read through the JCT, or indeed talk on a day-to-day basis, they'll actually recognize the words loss and expense, and they will actually recognize then what that actually occurs. So that actually is direct reference to the laws of exchange. So we have direct loss was the first limb, and we have indirect or consequential loss as being the second limb. So ultimately, what would be a direct loss, and of course that's an express contractual mechanism in the JCT. Okay, well, that's it for this morning, and thanks very much. And any questions, do let me know. Okay, thank you very much.
During the course of the seminar. In an issue of no contract under adjudication ADR procedures, does this mean no written contract or no direct contract for other reasons? For example, designer and a contractor or third party?
Yeah, okay, so one of the allegations that would sometimes be put forward would be whether spurious, or whether or not would a party try and avoid being a party to an adjudication. They may allege that there is no contract, or the terms of the contract have not come into place between the two parties in the actual adjudication itself. And that's where I was mentioning that if there is a relationship between the parties, if we can establish that there are those elements of a contract between those parties. And certainly as recently as 2 weeks ago, I had the argument as referring party where the respondent set out that there was no contract, which took probably about a day and a half of the adjudicator's time to actually go through the different elements of how the contract did actually suffice. But ultimately, parties may attempt to end the adjudication by suggesting that there is no contract between the parties. So ultimately, if there's no contract between, say, the designer and contractor or third party, there simply is no contract between them, because we've got the chain of causation going between the contractor to the employer to the consultant. So there wouldn't be any inherent rights unless there's a direct contractual link between those two in any event. So that's more likely going to fail for that point in time. This actually directly leads on to the next question, which was, can collateral warranties give rights to parties who would otherwise not be included in a contract? So that's exactly one of the instances that has been raised in the courts, which is whether or not there is now a direct link, and can you adjudicate on the fact that there is collateral warranties, and there has been cases where that has come into play. Ultimately, what a collateral warranty is a vehicle which allows the another party to have rights onto a separate contract of that basis. So there certainly has been quite a number of cases involved in that. In fact, one, but the limitation was an issue, which was based in Wales quite recently. So that certainly takes that in, yeah.
Okay, that's great. Thank you very much, Henry. And apologies for the slightly delayed start. The technical gremlins have got into our system there. And we hope to see you all again soon. We have another one of these at 5 o'clock tonight, which is about I Want My Money Getting Paid. And we've also now released our July seminar dates onto the website. So if anyone wants to have a look at those and make some bookings, please feel free, or drop me a line and we can sort that for you. In the meantime, please stay safe, everyone. We'll see you again soon. Take care. Thank you, Henry.
Thank you.